Okay.
Ready?
Yes, ma'am. Okay. Good afternoon, gentlemen.
Good afternoon, Your Honor.
Okay.
Good
Miss
afternoon, Judge Gibson. How are you today?
Finding you, sir.
Very well, thank you.
All right. Miss Clifton, when you're ready.
Shall I push play? Okay, this is
Okay.
case number 19016-609NF, Enhanced Center for Interventional Spine and Sports versus Auto Owners et al.
Mr. Counsel, for the record.
Good afternoon, Your Honor. Gary Blumberg on behalf of the plaintiff.
Michael Schwartz for Defendant Homeowners Insurance Company.
And Mr. Schwartz, this is homeowner's motion, so you may proceed.
Thank you, Your Honor. This case originated before Your Honor as a direct PIP suit brought by a woman named Kelly Johnson. That case was pending before Your Honor probably about a year ago. In that case, the underlying plaintiff, Ms. Johnson, violated a number of your discovery orders, and that resulted in you dismissing the case based in large part on her violation of your discovery orders. This motion is a motion for summary premised on those prior discovery violations. There's a published appellate case called Dawood versus State Farm. It's a Court of Appeals decision. That case says unequivocally that when the underlying claimant commits discovery violations and the court dismisses that claim because of those discovery violations, a later suit or claim by a no-fault provider is barred. The court held that the provider's claim is derivative. That's consistent with many years of Michigan law on this issue. And so the court dismissed that both the underlying claimant's claim in Dawood and the provider's derivative claim. It so happened in that case that the court entered an order referencing the defendant's brief. It said something to the effect of, for the reasons stated in defendant's brief. And in turn, defendant's brief in that case referred to MCR 2.313, which is the court rule that addresses a party's failure to engage in discovery. So in our case, what happened is Ms. Johnson failed to answer requests to admit, and she failed to answer other written discovery. There were a number of orders that the court entered in her case, which she violated, and it culminated in Your Honor dismissing her claim. The dismissal order had the very same language that was in Dawood. It referenced my brief that was filed on behalf of homeowners, and it said it was granted for the reasons stated in my briefs and by the court on the record. And just like in Dawood, my brief in that case referred to MCR 2.313, which again is the rule that says the court has authority to dismiss a claim because of a discovery violation. So Dawood is binding precedent. I don't think there's any argument to the contrary in this case, and it requires dismissal under C10. There's a second basis for my motion, which is res judicata. That's of course C7. There's three elements to res judicata. One is that the first action was decided on the merits. The plaintiff in this case has conceded that element in the response. The motion that you granted in the prior case was with prejudice. It's unquestionably on the merits. The second element is, could that matter that's contested in this case, could it have been resolved in the first action? We submit that that's true. It could have been. The lack of coverage for Ms. Johnson's claim was decided in the first case. Even if she didn't assert a specific claim for the enhanced bill in this case, the second element is met because she could have asserted a specific claim. Now, enhance will argue, they've argued in the response, and Mr. Blumberg is going to argue this for enhance in a moment. He's going to say, well,
I'm a little confused. He's mind reading now, Your Honor. I'm going to have to object to the mind reading as to what, I don't even know what I'm going to argue yet, and he knows what I'm going to argue. Go ahead, Mr. Schwartz. I apologize.
Thank you, Mr. Blumberg. Enhance argues in the response that the claim was assigned, that Ms. Johnson signed an assignment, and therefore she relinquished her right to pursue any claims for enhance. And so the dismissal of her case based on a discovery violation doesn't apply to enhance in this case. Here's why that argument's wrong. First of all, the assignment that she signed says that she assigned her claim that she had against auto owners. The court is probably familiar with this. Auto owners is a separate entity from homeowners. They are different insurance companies. Admittedly, they are under the same umbrella of companies, but they are different. They are not the same. If I assign my claim to State Farm, Allstate can't say that assignment applies to Allstate or vice versa. It's no different here just because they're related entities. They are separate. So even if plaintiff could win that argument and say the assignment was to homeowners, which it's not, even if they get to that point, the binding law in Michigan is that that doesn't matter, okay? I cited an unpublished case that recently came out called Medical Team. That case addressed nearly identical issues as this case. The provider says, wait, we have an assignment, therefore a dismissal of the underlying individual's case doesn't affect us. We can continue to pursue our claim. Court of Appeals expressly rejects that, says no way, no how. The assignment doesn't insulate a provider's claim from a prior judgment. The third element that we haven't addressed is whether the prior case involved the same parties or their privies. Certainly Enhance is not the same party as Ms. Johnson, but the case law says that they are in privity. And that case law I'm referring to is TCBI versus State Farm. It's a case from several years ago from the Court of Appeals. Most courts are now familiar with that because it's published in binding and says that a provider and an individual claimant stand in one another's shoes and are in privity. Medical Team, that unpublished case I just referred to a moment ago, says the same thing. The provider's claims as an assignee are necessarily and entirely derivative of and dependent on the insured's rights. That Medical Team case also said that a trial court's finding that a provider was not in privity is directly contrary to binding precedent of both the Supreme Court and the Court of Appeals. Two other points I want to make, and then I'll turn it over to Mr. Blumberg. The first is that in the response, Enhance refers to a case called Michigan Pain Management. It came out a few months ago. It's not only distinguishable, it's simply inapplicable. That case directly involved MCR 2.116C6. That's the core rule that says one party can't initiate multiple lawsuits. C6 is not an issue here. I'm not arguing that plaintiff or Ms. Johnson has initiated multiple lawsuits. It's just not applicable. The second thing I do want to address is a case called Mecosta, M-E-C-O-S-T-A. It wasn't briefed by any of the parties because it just came out. That is against my position. It's against the Medical Team case that I've been talking about. Those cases are directly in contrast with one another. They literally say the opposite things. And Mecosta is unpublished as well. So what happens when you have two unpublished cases and they conflict? You fall back on the published case law. And that's to say Dawood and TCBI, both of which say, provider, you're derivative, you're stuck with whatever happens to the individual. And in this case, Dawood mandates dismissal because of the prior dismissal of Ms. Johnson's claim.
Okay. Mr. Blumberg?
Wow.
Your Honor, we couldn't hear you there if you said something.
I heard Mr. Blumberg. So as much as you can mind read me, that one you got wrong. I heard that. So yes, I'm ready to proceed. Can you hear me?
There you go. Sorry about that.
That's okay.
Thanks.
Your Honor, I'm going to start at the end first, contrary to Mr. Schwartz's description, and he references very loosely throughout his argument all these cases that say this and say that, but that I'm going to point you to the case and what the case says, and I'm going to tell you Dawood does not say what he says it says, nor do any of the cases. He's just paraphrasing in a manner in which he believes it's favorable. Position is pretty simple with regard to this. This is a discovery issue in a case we were not involved in. And I agree that that there are cases that create some difficulty for us, but I want to refer you to the Macosta case. The Macosta case, actually, the reason why neither one of us have it is something that was issued on March 24, 2020. And as I read Mr. Schwartz's motion, I think that's the day he filed it. So somehow or other, there's some symmetry to that. Macosta actually involved a fraud claim that in the underlying patient's case, the carrier argued that the patient had committed fraud and dismissed the case, and Macosta dealt with that. And I just, rather than reference it by telling you what I think it says, I'm going to tell you what it does say. And what they're talking about here is an assignee sitting or standing in the shoes of the assignor. And the Court of Appeals said the following: that maxim, however, is nothing more than a shorthand reference for the well-settled principle that the assignee of property obtains no greater rights than the assignor had. It does not mean that the assignee remains in privity with the assignor in perpetuity, such that the assignor can intentionally or unintentionally alter the assignee's rights after the assignment, which is exactly what's going on here. They're arguing that a failure to answer requests for admissions, and I only saw one order. I wasn't a party to that case, the patient's case. I saw one order from this court and then a motion for reconsideration, and the order had dismissed it for discovery violations. We're clear about that, but I saw not multiple orders that were referenced by Mr. Schwartz. Now, I'm not saying there weren't any, but they weren't attached to his motion. There was one order attached. In any event, the court goes on to indicate, to the contrary, as Spectrum Health and Mary Freebed correctly note, with certain exceptions, the assignor relinquishes all power to alter the assignee's rights in the property. Now, meaning that you can't either intentionally or unintentionally, as they did here with, you can call the discovery violations or intentional or unintentional, affect the assignment that was done before. And I will point out to the court that this panel of the Court of Appeals, although it was unpublished, was mindful of TBCI, did reference that case in their brief, and so they were mindful of the law, and they went on to say the following: however, in this instance, application of the doctrine would obviate the assignment and effectively render it null and void, and deprive Spectrum Health and Mary Freebed of the right to pursue their claims. And that is exactly what the defense is trying to do in this particular case. We had an assignment. We were never put on notice of any issues with any discovery problems. We've had no discovery problems. We have done nothing to violate any court orders. And what they're attempting to do now is they're attempting to eliminate our claim by virtue of something a patient did or didn't do in the first instance. And then, secondly, and this is what these cases, and if you read this case, it'll tell you this, and I have two decisions out of the Eastern District, also not binding, but certainly persuasive on the exact same issue that's raised in the Macosta case and raised in our case. And that is that what they're doing is they're attempting to eliminate our claim by defeating a claim in another case, and that's exactly what they're doing. I will tell you that I believe the courts in Michigan and appellate courts are beginning to go away from this. There's a brand new published decision that does not have to do with this particular case, that talks about the fact that you can't use things obtained during the course of discovery to support your claim that the policy should be rescinded at the time. In other words, you can't develop a rescission claim after the fact. It's not relevant to our case. I'm just saying these cases are coming down now by the Court of Appeals, and they are They are moving away from this idea that no matter what the patient does in his or her case, it eliminates our case. In this particular case, there is absolutely no basis whatsoever for dismissing our claim. We have no discovery violations. The idea of eliminating our ability to pursue based upon post-assignment action is heightened by the fact that I believe, and Mr. Schwartz can correct me if I'm wrong, that the plaintiff in the patient's case hasn't appealed. So not only can't I challenge what went on in the circuit court to determine whether or not that activity of the patient should somehow bar our case post-assignment, but I can't even challenge it in the Court of Appeals, thereby eliminating my ability to pursue my client's claims and obtain a meritorious decision, something on the merits of client's claims. And if you read, and I'd be glad to supplement with this McCosta case that was referenced by Mr. Schwartz, if you read it, the other detailed opinions I got obtained subsequent to the filing of this from the Eastern District, they stand for the proposition that we are entitled to a meritorious decision to pursue our claim. And like I said, McCosta, that's a fraud claim. That's claiming underlying fraud on the part of the plaintiff in the Court of Appeals panel, which was signed on to by Kirsten Frank Kelly, which surprised the heck out of me. She's a former Wayne County Circuit Court judge and a very good judge, but a very conservative judge. So I believe the motion should be denied. As to the issues of homeowners and auto owners, they're the same carrier, and that's, they have the same claims department. Everything is the same address, same everything. In fact, we sued them both in all of our cases because they create difficulties if we don't. I think the motion should be denied.
Mr. Schwartz?
Thank you. 3 points in response to that. I think Mr. Blumberg did a fair job summarizing this new McCosta case. I thought I did a decent job of that as well. The problem with McCosta is, like I said, medical team, the other case, says the exact opposite. So as we start quoting cases, let me just put this in the record. It was attached to my reply brief, but in that case, the provider argued, and here's what the court says. The provider further appears to believe that Kalamazos, that's the underlying claimant, Kalamazos' assignment of his right to obtain benefits based on the services provided by provider somehow insulates provider's claim from the effect of the Wayne Circuit Court judgment. However, an assignee cannot obtain any greater right than the assigner had with respect to past due or presently due benefits from the no-fault insurer. An assignment does not have some strange alchemistic power to transform a dross and worthless cause of action into the pure gold from which a judgment might be wrought. That's a mouthful, but it says exactly opposite of what Enhance is arguing and what McCosta says. The medical team case also addressed DCBI. They acknowledge that it's before all this assignment law came in to play with no-fault claims, but says it doesn't change the analysis at all. So I go back to my point that I made originally, which is you have 2 unpublished cases that say polar opposite things, and you fall back on the published law that says, 1, that providers are in privity with the claimants, and 2, that a discovery violation under Dawood renders the entire claim void effectively. 2, my second point is, and I made this briefly before, the assignment, it's attached as Exhibit F to my motion. It references auto owners. They are different companies. I don't know how you get around this. There was a Geico decision recently that was very similar. The plaintiff had sued a one Geico entity and said basically that's good enough for everybody under the Geico umbrella, but it's not. You have to sue the right entity. So even if the plaintiff assigned her claim to auto owners, it doesn't affect the fact that homeowners is the right carrier and has obtained summary disposition and is trying to enforce the holding in Dawood here. Third thing is Mr. Blumberg talked about notice, that perhaps Enhance might be prejudiced because they didn't know what was going on in the underlying case. They didn't know that there were discovery violations. There was a recent case that's set for publication. It literally came out last week. It addresses a separate issue, but I think the reasoning is apt here. That case says that when you have a claimant sign a release, it's binding on a provider if that provider doesn't provide notice that the claim has been assigned, okay? And in this case, I had my adjuster search the file one more time this morning. Enhance never submitted an assignment to us before suit was filed. So by the time Ms. Johnson's claim had been dismissed based on the discovery violations, Enhance had never provided this purported assignment. The first time we saw it was when they filed suit. So, when we talk about notice, I don't know what I'm supposed to do in terms of protecting Mr. Blumberg's client if I don't know that the claim was assigned. I'm working under the assumption without notice that Ms. Johnson had authority to litigate that claim. So for all of the reasons that I've stated, including the binding law that applies here, I think the court has to dismiss this case.
If I might, Your Honor.
Yes.
As to the notice of assignment, counsel is talking without evidence, and if we had the evidence, I would have seen it, and I didn't see it attached to his brief. There isn't a carrier's claim person who could stand under oath today or sign an affidavit who said they didn't know that a medical provider assigned the claim when they all demand proof of assignments or revocation of assignments in resolution of all the cases. They know every one of these cases is assigned. And so the suggestion that they didn't know and what they could have done, and I don't think it's important to your issue. We've sued both companies. We have both companies in here. Whether they knew about one or knew about the other is not really a relevant inquiry. We have an appropriate assignment to proceed. When counsel read the provision from what he says is a conflicting case, he read language that talked about the assigner's rights as of the time of the assignment, which is exactly what's talked about by Macosta. They do not conflict. They are the same. What that court dealt with were the rights, and you can't obtain any greater rights at the time of that assignment than the assigner had. But that's not the issue in this case. The issue in this case is, should the carrier be allowed to avoid responsibility for payable bills because they obtained a discovery violation in another case? Framed another way, why should they avoid the responsibility and not have to pay a bill that's covered when the activity in your patient's case had nothing to do with their ability to defend this case? Nothing. It's got nothing to do with it. He never attempted to depose her. He never attempted to send non-party interrogatories to her, permitted by the court rule, non-party requests for admissions. He never attempted to do anything. His whole idea is, I was lucky enough to get rid of the patient's case after the assignment. And because I got rid of the patient's case after the assignment, I should also get rid of Mr. Blumberg's case, even though what happened in the patient's case had nothing to do with, or has nothing to do with, the defense of this case. He's trying to benefit by it. And I think the Macosta decision is consistent with the other decision, and it's an appropriate way to look at an assignment and what can be done with an assigner and an assignee and the assignee's rights long after the assignment was signed. I believe the motion should be denied.
Okay. The court notes that MCR 2.313 does allow for the dismissal of a claim for a discovery violation, and it's clear that that's the basis on which the court dismissed Ms. Johnson's claim. We have DeWoo, which was a 2016 case, which was a published decision, and it basically said that the providers stand in the shoes of the underlying claimant. And, like I said, that's a published decision, and it articulates it, and it's been the law for a while, and we know it has. I know Mr. Blumberg would venture to argue differently. And, we have now the Macosta case, which was recently decided in March. And then we also have the medical team case, which was decided, I think, in February of 2020. And those, you can look at them in different ways, but, there's a perspective that can be looked at, that they are opposite decisions as opposed to being similar. There may be some aspects of it which look in the same direction, but the underlying decisions were diametrically opposed. And when, as Mr. Schwartz indicated, when you have that conflict, and as he stated, these are both unpublished decisions, you have to revert to that which was published. And that takes us back to Daewoods, which says that the provider's claims are barred as well. They stand in the shoes of the underlying claimant. So for that reason, the court feels that Daewood is presidential binding, and pursuant to 2.116C10, that the case should be dismissed. Additionally, we can go and look to 2.116C7 in terms of the res judicata issues. And as Mr. Schwartz indicated, the three prongs of that test have been met. We look to first whether or not the case had been decided on the merits, and the case law is clear that once a summary disposition is granted, and it's determined that it's dismissed on the merits, and that satisfies the first prerequisite of res judicata. The second prerequisite is that the matter contested in the second action was or could have been resolved in the first. And it's clear that this was a claim that arose out of services that were assumed to be provided to Ms. Johnson. So it could have been raised in that instance. And third, whether or not the parties are in privy. Yes, Enhanced Center is a different entity, but Enhanced did provide services to Ms. Johnson, and that's consistent with them standing in his shoes pursuant to the holdings in TBCI versus State Farm. So even taking evidence in light most favorable to the non-moving party, the court finds that there's a sufficient basis to grant the motion for summary disposition. And we have these competing unpublished decisions. So Mr. Blumberg, if you feel appropriate, this might be something that you would like to take up so that they can give us some clarification.
Your Honor, I understand the court's ruling, and I've been thinking about that, and who knows the direction that they're going to go in, and I understand you feel constrained based upon the prior published decisions. And honestly, to be perfectly candid, and Mr. Schwartz and I have a real good relationship, for the life of me, why is the Court of Appeals moving away from these published decisions? And if they are moving away from these published decisions, they ought to publish the decision.
Exactly.
So lawyers like us in courts like Your Honor, and I know you read the cases and read the law, know what's going on here. Why would it has to come out with an unpublished decision and reference that it knows about the published decisions, but it's coming out with this decision? I believe it's the direction they're going. If I take an appeal, they may hate me or may love me on the plaintiff's bar side. So we never know, but I appreciate the court's.
Right. And like I said, I look for the clarity too, because that's what we rely on. We rely on the case law that comes out of the Court of Appeals to make our rulings. We, deal with the law. I don't try to create law, but, I can interpret it. And the only way I can interpret it is if I have some direction from the Court of Appeals or the Supreme Court. Okay. Thank you very much, Mr. Schwartz. We'll look for an order of dismissal. Thank you so very much, gentlemen.
Thank you,
Thank you, Your Honor.
Thank you. Take care. Okay, Kimberly, that closes that up.
Okay. Judge Fran sent some instructions to me to try to put a message, to post a message to, it says customizing Zoom waiting room messages, to let the people know to email or call me to say that they're in there, if they're in there like for any length of time.
Mm-hmm.
So I tried to do it, but obviously it didn't take. So you might have to, or I might have to use your log on.
Yeah, you can do that. You go ahead and log on, because like I said, I think I'm doing a yeoman's job. I'm not technically savvy. So
You're still recording, Judge.
Oops.